Back, everybody. The Supreme Court has overturned a 1980s precedent known as the Chevron doctrine. That decision could actually undercut federal agencies, including the FDA. Joining us right now for more on this is former FDA Commissioner and CNBC contributor Dr. Scott Gottlieb. And Dr. Gottlieb, thank you for being here. I wanted to talk to you about this, not just in your role as the former FDA Commissioner, but also as someone who used to work at the American Enterprise Institute, which takes the view that big government's not always a great thing. And I just wonder how you are looking at this decision that was originally brought by fishermen in the Atlantic who were unhappy with having to pay for monitors who were watching over what they were hauling in. Why don't you talk through how you see all of this and what it means?
Right, and I'm still at the American Enterprise Institute. Look, I think a lot of conservatives viewed this as a way to constrain the administrative state, that regulatory agencies had expanded the scope of their authority into new areas that Congress hadn't clearly delineated. And now agencies aren't going to be able to do that. When you were a regulator, so when I was at FDA, if we issued rulemaking and we were interpreting the statute in areas of ambiguity to try to apply our regulatory oversight to new areas of supervision, new product areas, we generally, as long as we went through rulemaking, we generally felt that the courts would defer to us under Chevron doctrine. And that was a reason to go through the rulemaking process, so that deference would attach. Now that presumption no longer exists, and so you're going to have to go back to Congress in many cases, get explicit authority if you want to extend the agency's jurisdiction into a new product area. Now, with respect to FDA specifically, I would expect that the courts will still defer to FDA on fact-based decision-making with respect to the drug approval process or medical product review. Courts and Congress has given the agency broad grants of authority in those areas to make fact-based, science-based decisions. But when the agency is trying to delineate its regulatory supervision over new product areas, for example, laboratory-developed tests or certain food safety rules, I think those are the areas where the agency's authority now is going to be more ambiguous. They're going to be challenged. And Congress ultimately is going to have to come in and probably re-legislate some of these areas to make sure that the agency's jurisdiction and its authority in places where you want the agency to be regulating, where it's very clear.
Could you have gone after Juul the way you did in their marketing towards kids under this new ruling? Or this
it's
ruling
quite
being
possible.
overturned?
Right. So one of the rules that could very likely be challenged is the agency's efforts to try to regulate flavored vapes, for example. A lot of what we did when we went after Juul was taking enforcement actions under the existing statute and regulations, which I think was pretty ironclad. I think we were on firm ground. And we were challenged in courts, and we prevailed not under Chevron deference. But I think that have been some rules that have been promulgated in the intervening years, particularly around flavored tobacco products, where the agency could face a challenge. That would be one of the more immediate places I think you'll see some litigation now as a result of this decision. You know, you led at the top with the politics of this. It's interesting to just go back to 1984 when this doctrine was first established. It was actually conservatives that were fighting for it because they felt that the courts were second-guessing regulatory agencies. Remember, those regulatory agencies were under the control of a Republican president at the time, and they felt that the regulatory agencies should have more jurisdiction and not the courts. And so now you see the politics of this reversed, to your point.